Welcome back to Unchained Frequency. This is episode 4 in our series on the constitutional right to travel. Today, we examine a landmark case that not only reaffirmed Shapiro versus Thompson, but also extended its protection. Saenz versus Roe, 526 U.S. 489, 1999. In this case, the Supreme Court ruled that states cannot withhold full public benefits from new residents based solely on how long they have lived in the state. Why does this matter in 2025? Because states still impose rules, from licensing barriers and waiting periods to residency requirements, that can act as obstacles to free movement. We will break down the facts, analyze the court's reasoning, show how other courts have cited science to invalidate unequal residency requirements, and give you practical ways to use this case when facing unfair state restrictions. Let's get into it. Background and facts of the case. In 1992, California amended its welfare rules to restrict new residents for their first year to benefits equal to what they would have received in their prior state, not what long-term Californians received. This was codified as a California Welfare and Inst Code Section 11450.03. The 1996 Federal Welfare Reform, PRWORA, seemed to permit states to cap benefits for new arrivals for up to 12 months, and California argued its law conformed to this federal policy. Brenda Rowe, along with other residents, sued, arguing that Californians' law punished people for moving and discriminating against them, violating the constitutional right to travel, equal protection, and privileges or immunities guarantees. The district court initially blocked enforcement of the law. The Ninth Circuit agreed, and the U.S. Supreme Court agreed to review the case. Legal issues and holdings. Issue presented: does a state law that withholds benefits from new residents for a set period violate the Constitution's right to travel and the 14th Amendment? That's an interesting question. Key holdings and reasonings. 1. 3 components of the right to travel. The court confirmed the right to travel includes 1. Entering any state. 2. Being treated as a welcome visitor. And 3. Being treated equally as a resident once you move and intend to stay. 2. Privileges or immunities clause. The court found California's law discriminated against new residents by denying them important privileges available to others, violating the 14th Amendment's privileges or immunities clause. 3. Durational residency, equal penalty. Treating new residents differently imposes a penalty on their right to move by making relocation costly or unattractive. The state's main justification, budget savings, was not compelling enough interest to justify this penalty. 4. Strict scrutiny. Because a foundational right was burdened, the court applied strict scrutiny, requiring the state to show a compelling need for the rule, which California failed to do so. 5. Federal authorization equals constitutional. Although Congress tried to give states leeway through PRWORA, it cannot authorize rules that violate the 14th Amendment. Federal law cannot empower states to breach the Constitution. 6. Final holding. California's law was declared unconstitutional. Newcomers cannot be subjected to lesser treatment just because they recently moved. 3. Importance why Saenz strengthens the right to travel. Saenz built on Shapiro by explicitly protecting new residents from being treated as second class after moving. States now cannot cite budget concerns or administrative convenience as valid reasons to discriminate based on length of residency. The decision revitalized the long dormant privileges or immunities clause, making it a practical defense against state efforts to disadvantage newcomers. Science confirms that new residents must be integrated fully with the same rights and benefits as longer-term residents, reinforcing freedom of movement as a Central American value. How courts and laws have cited and used Saenz. This is very important. Since Saenz, numerous durational residency statutes, whether they limited benefits, licenses, or education access, have been invalidated using its logic. The ruling is frequently cited as modern authority against any public that singles out new arrivals for lesser treatment. Legal scholars view Saenz as one of the era's most important right to travel decisions, shifting some constitutional analysis away from equal protection and toward privileges or immunities. Lower courts have referenced Saenz in challenges to residency-based restriction in areas such as welfare, professional licenses, and school admissions. Local examples vary and are worth researching for your state. Revelations in the 2025, why it still matters. States continue to implement residencies, waiting, and documentations requirements that can act as barriers for new arrivals. Administrative policies, even if justified as fraud preventions or planning, may operate as forbidden durational classification under Saenz. The case remains a strong tool for challenging a new resident discriminations, whether in court or in negotiation with state authorities. Public understanding of Saenz supports both legal challenges and civic resistance to mobility restrictions, which are increasingly relevant as state regulation intensifies. Additional legal context and Saenz did not overrule early cases like Shapiro. It clarified and extended them. Earlier right to travel precedents remain good law. The court distinguished between durational residency rules, which are unconstitutional, and bona fide residency requirements. States may still insist on general presence and intent to stay for certain benefits, provided they do not penalize newcomers unjustly. While the right to travel is fundamental, legitimate state needs, fraud prevention, administrative order may still be recognized, but rarely justify penalizes movement. Saenz's main application is in benefit and public aid contexts, purely private or regulatory matters, such as driver's licenses, may be subject to different analysis. Takeaways in which you can use, and pay attention to this. Saenz versus Roe is essential. It modernizes and reinforces constitutional protection for mobility and assures that new residents are not penalized, which they have been doing. And they still do that till this day. They still use this type of unconstitutional mandates and policies against the people. If you encounter residency-based delays, license hurdles, or benefit denials, invoke Saenz as a direct source of constitutional protection. When challenged, you can say, quote, "You can't withhold rights from me because I'm new here." Saenz says that's unconstitutional. This is not just a historical precedent. It is a living, acting principle you can use today. To wrap it up, Saenz versus Roe isn't just a historical case. It is active protection for every American's right to move freely and be treated equally, no matter where you go. If you found this analysis valuable, share it, save it, and make this knowledge your shield. Next time, we will continue with license versus liberty, examining how states try to convert your right to privileges. You can also follow me on Substack.com, Facebook. I'm on Facebook, YouTube. Just look for Unchained Frequency. I'm your host, Malik Liberty, and you're listening to Unchained Frequency. No fluff, no fear, just facts. Until next time.